थोड़ा सा वेट कर लें, भी ऑडियो का वहाँ से आ नहीं रहा है ऑडियो, जैसे ऑडियो आएगा वहाँ से तो आप तक ऑडियो पहुँच जाएगा। B.ed की तरफ से सीनियर एडवोकेट PS पटवालिया आ गए और तुषार मेहता भी आए हुए हैं थोड़ी देर में। अब एक बार डिस्कस चल रहा है, जैसे डिस्कस होता है उनका, जस्टिस भी आपस में डिस्कस कर रहे हैं और तुषार मेहता और सीनियर एडवोकेट PS पटवालिया जी भी डिस्कस कर रहे हैं आपस में। ए और अमित पवन है वो भी डिस्कस कर रहे हैं उनसे कुछ उसको लेकर। बहुत ही अहम सुनवाई होने वाली है। आज की सुनवाई होगी, बहुत ही अहम महत्वपूर्ण सुनवाई है B.ed के लिए। ये फाइनल सुनवाई है। इस सुनवाई के
And this is only a charge sheet in one of the FIRs.
Main point on which that though at the material point of time, charge had been filed against both
The first accused in the FIR, my lord,
first accused
who was not a party here.
the FIR. Others does not fight. That
Please, my lord.
the names were in the accused persons.
The charge that I have given the
Charge sheet had not been filed at that point of time. Subsequently, admitted position is that charge sheet has been submitted. We do not find any conduct attributable to the bill petition. And the petitioner bill which would warrant cancelling of the order of the bill. So, the discrepancy on the question of heading of charge sheet does not materially affect the position so far as grant of anticipatory bail was grant of anticipatory bail is concerned. Hence, we dismiss the investigation.
The tortures may only direct that they let them cooperate because the further investigation is still on.
The petitioners in bail should the petitioners who have obtained bail should cooperate with the investigation.
As a main court.
Then,
Oblige.
yes,
Wait, please. I am seeking a release, my lord, in furtherance of the lordship's judgment, my lord. Let me tell you what IMCS for the B.ed candidates. We are also in the process of filing an application.
Fifth bite of the cherry. You've dismissed 5 so far.
In the Supreme Court, we don't argue like this, not. Number one. You do. Number two. Sorry. That's what you do. Yes. Yes. Yes.
Solicitor,
Yes.
clearly and then
Yes. But just one point I want to make. So far as Madhya Pradesh is concerned, in Bihar also this issue arose. And Bihar High Court has passed a judgment on 6th December 23 saying that B.ed is not eligible and about 20,000 people are going to lose their jobs. That SLP is in the process of being filed. One has been filed.
My lord, I have no problem with your lordship's judgment.
You think that whether it's
Prospective or retrospective, that's all. And my lord, if it is not prospective, okay, but if it is not prospective, lakhs of people are affected.
you want us to clarify those who have already got appointment.
They will not be, yes. My lord,
Correct. That's all.
page 61, my lord, page
selection, appointment.
Yes.
appoint. Yes, my lord, appoint, correct. Yes.
Actual
My lord, this is page 61. My lords have envisaged this my lord, contingency. My lord, page 6, my lordships were pleased to say.
Then where are you in trouble still?
No, this is for Rajasthan, my lord. I am Madhya Pradesh. I was not a party before your lordship, my lord.
So this would cover all the states.
Yes, my lord, that it will be prospective in operation. That's all. Having made the above determination, we all the same are also of the considered opinion that state of Rajasthan before your lordship.
But till then it was a law.
Yes,
You should have followed it.
and we followed it, my lord, because that was the law. That's all.
Have heard London Council appearing for the parties. MA number 4303 of 2024.
We are opposing this.
But those who are appointed, you want
Your lordship, now we'll all get, if these people are, Julia saying last time, that we are looking at the interests of the children. It's not about each of us having a 19(1)G right fighting against each other. It's not a service matter.
These are all
So, I'm sorry, I was told that this is not the practice of the court. So, let's just proceed. Now it's my turn. Now, yeah, Mr. Patola knows it.
Everything. That's all.
Subject to
My lords, can we make us up to my learned consider? This was a central government notification under the NCTE Act of 2018. On 25th of November 2020, 2021, Rajasthan High Court struck it down. It was quashed. Once a central government notification stood quashed, which applied to states across the country, it stood quashed for everyone. When the matter was carried to my lord, yes, my lord, so I just
this proposition.
my lords, I can satisfy you on that because
There have been many judgments where
no, my lords, I will be able to satisfy my lords on this aspect because the once is a central legislation and it has a uniform application, then once it is struck down, it's struck down across board. I'll be able to satisfy that. Then, my lords, when the matter was carried to this court, my lord said, did not stay the judgment of the High Court, but said subject to the outcome. Eventually, my lords upheld the quashing of that particular NCTE notification. Now, so far as Madhya Pradesh is concerned, there are two dates which are very important. My lords, this on 25th November 2021. Now, the notification that was issued by the Pradesh government for the purpose of holding the examination was in 2022, when the notification already stood quashed. The writ petition in Madhya Pradesh High Court came
He is in
find-
Rajasthan.
My lords,
He's not concerned.
my lords,
We are all Madhya Pradesh. We are all Madhya Pradesh.
now please
I
have
don't
it
have any
as a courtesy to us also. We may not have the parallel this thing on the other side. Now, so my lords, there's one more submission which is very important.
as regards Uttar Pradesh, there is
Yes.
an application.
This is the application.
This is the application.
This
That's
application.
our application.
Please appreciate one thing, and this must be pointed out.
I don't think
by
he has any
Judge-
application.
Mr. Mehta, for a minute.
I have an application, not the,
One
he
minute.
may address
My
it or
lords,
not. I have
11
an application.
August
I will attach.
2023, my lords finally upheld the Rajasthan High Court. The appointments in Madhya Pradesh carried on even after my lord's judgment. Now, I do not think there is any justification once my lords had quashed. And today to turn up and say, we have given appointment to 11,000.
Appointments which are after the judgment will go. Correct.
My lords, Rajasthan High Court judgment. Rajasthan High Court judgment. I will make good that law.
No,
I
are
will
this?
make good.
Are.
My lords, please appreciate. Please appreciate.
Prior to this.
My lords, can I? Please, my lords.
We are with you as far as diploma is a qualification, B.ed is not a qualification. There's so much of unemployment in this country. If somebody has got a job,
May I respond
No
to
one-
that?
Manoj,
My lords, let
that
me
we don't
respond
have.
to that. Let me respond.
11,000 of us don't have jobs.
My lords,
No, we won't. It's not. That only thing is quality of your training. But these people
my lords, I want to answer.
These people have done the course also, but they are not properly trained. Yes, they don't have the course. Now, we ask them.
My lords, may I answer this on both of the aspects, please? Number one, as the unemployment aspect is concerned. My lords, it's like one shoe or the other, because we are also as many numbers who are today qualified, who are eligible, who were entitled to these particular jobs and have been kept out. So if we talk about 11,000 coming out, there is equally 11,000, those numbers will get an employment. So it is not a case of non-suiting one or, giving away those employments won't be there, but there are people who are waiting. Number two, my lord said that we will get the jobs now. We will not. And may I explain why it will not happen? My lords, these were qualifications and jobs for a particular year. We have not been allowed into this. As we go forward, there are other batches which are ready. So therefore, the zone of consideration of the eligible candidates increases far more. So those of us who will go out now from D-Led will now go into a competition with large mode. But so far as B.ed is concerned, my lord, we can come only in that primary, much larger. So my lords, while we get deprived of these jobs and they have many other opportunities, and particularly in light of the judgment, and I would say at least from 2021, when my lords 61, let me put that in a perspective how my lords had put it. My lord said that until there was a determination by Rajasthan High Court, because what happened when the notification came from NCTE, Rajasthan state did not follow the notification. It non-suited the B.ed and said only D.Led can be here. My lords, what happened then what happened then is the High Court and my lords have observed TE notification, which is binding on the state. So state by itself could not have removed the B.ed candidates till such time as the court watched it. And that is right, my lords. That's absolutely correct. Today what happens is that NCTE notification stood quashed on 25th of November 2021. That was a central notification. Once it stood quashed on 25th November 2021, exams held in advertisements issued thereafter, where B.ed were allowed to participate and given an employment with full submission, were completely unqualified. It wouldn't have been done. But what I request my lords to consider is this, that the state so brazenly, notwithstanding the fact that they were aware, proceedings by my lords dismissing such applications from different states. Out of that, 2 petitions and 1 application in Arnab Ghosh. All 3 of them had prayed for prospective overruling. So, that when my lords have already
Their
taken
appointments were not made,
my lords,
wanted to be appointed.
courtesy for my learned colleague on the other side. Yes, the compilation and the overruling. Here, my lords.
What state you are in?
Lord, only one interjection with your lordship's permission. Your lordships would see the wash notification say,
I haven't finished.
that only a minute.
We haven't yet finished. You can take your time.
You know what I'm going to
My
say.
lords have asked this.
Only a minute, my lord. My lord, the wash notification says 2 qualifications permissible, diploma and B.ed. They also, they means I don't know who are ABCD, but diploma holders also participated. They could not make it, they were not successful. Thereafter, your lordships were pleased to say that B.ed part is not legal.
My lords, as of today, there is no. My lords, that's the
So they
compilation.
participated, did not
My lords, first of
succeed,
all, let
and now they want the house.
And one line
my lords,
not
can I?
every state has its own rules. Whatever name it's called, there is this TET also. So the figures show that's quite a many of the B.ed qualified in proportion are the ones who are qualifying TET than them. I don't know how it's happening. Or if it is not happening, then many of the B.ed qualified have qualified TET, diplomas have not. So they have gone and you have got it. That is how.
They are overqualified, my lord, maybe.
Not overqualified. No, they're not qualified.
No training at all.
You are not overqualified.
6 months training.
You are not qualified. Not qualified at all. They are qualified.
Yeah.
But when you are made qualified, both of you had to undergo this test called DET. Some of you qualified, they did not, so you got it. That's all.
Yes, that may
My lords, in our case, we are qualified.
DET was a
and we are
pre-qualification for
We
application.
are TET and we are
DET
DET.
was
My
a
lords, we are all
pre-qualification for
qualified.
application.
Now, my lords, let me show you the
Which
bunch of orders.
application are we?
My lords, we are under.
your lordship see page the para 30
My lords, can I show those
of
orders?
only a minute. Page
Prospective
38.
overruling has been rejected.
Page 38, my lord.
Perspective of the matter which we are hearing.
My lords,
First, let us hear
yes, my lords, can I just show the prospective overruling having been already rejected by
My application
with
is an
express
argument.
prayers? My lords, I have handed this compilation of orders which have been passed by my lords.
MA number 4303 of
Yes, my lords, that's the one which is.
this
Yes.
pertains to.
So that is state of Madhya Pradesh application
Okay.
filed by me, only saying, my lord, that there is if your lordship,
My lords, can I?
Madhya Pradesh government, I have moved an application for Madhya Pradesh government. Lordship's judgment at para 30
Can I
I'll just-
part. Can I finish
okay.
on the
This
prospecting?
only a minute has been
Just one
hijacked.
minute.
Let us see what you want.
Lord, your lordships were pleased to record this. Lord, para 30 of the judgment. The sequence of events which are now well established by the documents which were placed before Rajasthan High Court and before this court make it clear that the decision as a qualification was apparently requested that since the primary classes of central school sufficient number of trained diploma holders are not available, they may be permitted to appoint DA.
Yes.
So they are in demand, they'll get the job. Manoj, what they are now doing,
Rajasthan. We are
and that's where Manoj, the
state to state.
Yes.
So Rajasthan, there are too many.
So, Manoj, there are just one. There are 5 other states where we are in the process of.
I'm
Not even a
Manoj,
party, Manoj.
Manoj,
Hear us.
the central agency, Manoj, KVS. I'm sorry, Manoj, we are. Manoj, no, Manoj, KVS has given Manoj, as it appears, right to NCT for all states. This is the problem, therefore include B.ed. Now, be that as it may, but it's 2 years down the line, they must have changed their position, Manoj. They must have taken loans, they have taken loans. They would not get any benefit. They are qualified, they will not be appointed.
The prime officer means that those who were appointed before the judgment was rendered,
Yes.
okay, their employment of to be retained.
Unless they were protected by a high court's order which said what happens here. Unless, because otherwise, let me just
From giving prospectivity.
Mr. Mehta will run this court now. I mean, every time I say open my mouth, he has to interrupt.
Manoj, I do not know, Manoj. I sometimes
I can't
wonder
assure anything.
whether he is inherently rude or he has taken some course, Manoj.
Not from you.
The entire exercise with
He seems to have undergone some
petition.
special training, Manoj.
May I just submit one thing? There is already a writ petition
Learning from
wherein we had sought
We haven't asked you.
I'm sorry.
my
I'm not.
We are only examining
We're just.
Uttar Pradesh.
We are just reacting on the Madhya Pradesh question. Yeah. Yes, there was, which has not been placed by them, which is not referred to in the advertisement either. So we have copies of it.
my lords, it's in that compilation.
No, it's not.
7.
We're giving it
Let
separate.
them file a reply, Manoj. Let them file a reply. Proper reply, Manoj. We can't, Manoj.
No, they should have placed it, is all I'm saying. They should have placed it. It's the
Do not
state.
know, Manoj.
It's the government of Madhya Pradesh who has appeared through Assistant Solicitor General and Government Advocate. Now, if I may just read this and please note a few dates. This is very relevant. The Rajasthan High Court's judgment is dated 25th November 2021. So with effect from 25th November 2021, following the Kusum Ingots principle, which is well laid out, once a central notification is struck down, it stands struck down for everywhere in the country. There's no exception to it. Yes, but I'm just telling you, Lordship, 25th November 2021. Now just see that they are represented. Advocate, Assistant Solicitor General, they're all represented. Challenge here, this is the 4th para, is to the virus of the eligibility condition for direct recruitment for the post of primary teacher to the extent it prescribes B.ed degree to be one of the essential qualifications and notification of similar nature. Yes, writ petitions are pending. Now they have told the court, and that is in the compilation handed up, it's the last order. They have told the court there that our applications are pending here, they have to be taken up.
We cannot pass any order.
That is exactly it. Now,
They are really framed in the application.
yes,
That your judgment should be prospective, has to be prospective.
yes,
If we hold so,
yes.
then let
Lords, this or fact, this the fact are that the same notification, your 2018 NCT notification, and the two advertisements pursuant thereto are challenged in this. Now, when this came up for the first time, judgment which quashed the NCT notification. So, primary argument that your lordship are being faced with is this: what is the effect of the Rajasthan High Court judgment on all the other states? Which Rajasthan High Court judgment, to the extent that it quashed the NCT notification, has been sustained by this court. So the Rajasthan High Court judgment, which merges, is dated 25th November 2021. Now that struck down a central notification, therefore it's binding everywhere, which is why when the matter was taken up, Devesh's matter was taken up by your lordship, it notes the fact that apart from Rajasthan, UP,
Correct.
yes,
Whenever you are out, very appealing.
I have,
But
yes,
problem
I agree. So you dealt with, correct. So now the first question. No, I'm sorry. Correct. Yes.
go upward.
After 25th November 21. Correct. So after 25th November 21, anybody who issued advertisements were doing so at their peril, which is why 3 other states apart from Rajasthan came to this court. Your lordships had them all as the facts of Rajasthan. We'll take a look at Rajasthan and give a judgment based on Rajasthan. Secondly, this is not the first application. This is not the first special bench of your lordship disturbing yourself at 2 o'clock. We've been before you before. No. So the question is, those clarification applications, what were the prayers there and what your lordship said there? They asked for the same thing. They said prospective. They said allow it to be prospective. Your lordship said no, nothing doing. In one case it was dismissed. In 2 cases it was withdrawn. In the 4th case, which is Bihar, while Bihar is not a party before us in these proceedings, we believe that the judgment in Devesh Sharma will be fully implemented by the state of Bihar without passing that direction, and said that all consequential advertisements, notifications, etc. after 2000, the Bihar High Court judgment follows Devesh Sharma. Against which, if another date is given, apart from this one application of Madhya Pradesh, you'll find an SLP of Bihar, you'll find other applications, and Devesh Sharma will be opened up all over again.
Your Lordship, a wrong statement has been made with
allow me
the MA that was filed. It was not on behalf of appointed candidates.
That's not on. There are 5 applications. I don't know which one. This is particular. Now, if your lordship will just take up that compilation, this is to show you that fully aware of the Supreme Court's interim order that your lordships passed in the Rajasthan matter, Madhya Pradesh said that all appointments would be the subject matter of the final order of the apex court. So now, the advertisements that they issued should have told these new candidates coming in ineligible that look, we have made this statement before the High Court. It's proceeding. It's not a simple matter of saying that they were caught unawares. Nobody was caught unawares. Everybody knew. All the other states, all the other applicants who were B.ed candidates had intervened before this court, made arguments, many of them by counsel present today. Now see the advertisement dates of Madhya Pradesh, which is relevant.
After this
2 advertisements.
Only one, my learned friend has something to say.
Just otherwise you don't understand anything.
Yes, the 2 advertisements
is
by Madhya Pradesh are 19th October 2022
16th November.
and 16th November 2022.
After this order.
This is both after the order of the judgment of the Rajasthan High Court, which was not stayed by this court, and the High Court's interim order in Madhya Pradesh. Interestingly, what the Rajasthan High Court did was to quash the notification. Therefore, B.ed couldn't take part. When they came to your lordships in SLP, the B.ed candidates as well as the state, your lordships did not stay the judgment and said that all appointments made pursuant to the Rajasthan High Court judgment is subject to the outcome of this. That means without B.ed candidates, appointments were made, and therefore it would be subject matter or subject to the outcome of Devesh. So if Devesh finally decided to reverse the Rajasthan judgment,
then the B.ed candidates would get their rights for the first time. That is what happened in Rajasthan. Same has to follow suit for all the states, and that's what your lordships have said. Now, makes it clear that it will be subject to the outcome. Outcome has come now. This order can't say, sorry, ignore that order completely, not even placing it before your lordships. Let the clock starting from the judge. Yes.
My lord, same has happened in Calcutta High Court as well.
But I just want to tell your lordships two things. Yeah. He will come, Alan. It's there. It's there. We have to do it. There is already
No format of a bridge close every 2 days.
no. Manoj, let me.
How many institutions, the primary?
Let me state-wise, Manoj. Manoj, let me tell your lordships. Let me tell your lordships two things. Firstly, after the Rajasthan judgment, your lordship recollects. We had relied on it. The Himachal High Court on 26 November 2021 took a diamond, did not follow Rajasthan, said 28th October notification is and needs to be followed. So,
What they may not be knowing about
so
Rajasthan.
no, it is now.
What,
That was the 25th, that was the 26th.
my lord, what my lord prevails is your lordship's judgment. My lord, divergent views do not matter.
And Calcutta High Court Division Bench also took the view that notwithstanding Rajasthan, so the notification is valid and in the jurisdiction of Calcutta, that notification was relied upon and appointments made. So really the cutoff, really the act falls. The act really falls on the day when your lordships decided is point number one. Point number two, they have not given us this compilation of judgments they are relying on.
Who are they? I mean, they're not even parties here.
So far as we have been able to learn,
It's not even a Madhya Pradesh batch, Manoj. I'm sorry, we came here for one application.
this is what the
Taking your lordship to that.
appointees of Madhya Pradesh. And I am also appearing for the appointees of Bihar, whose SLP is in the pipeline. Yes,
You are challenging Bihar's order.
yes, there are what
As a counsel, he is in Bihar also. Clients are different.
exactly. I am for Devesh. I am Devesh Sharma. So I am only saying, Lord, supporting the application of solicitor saying.
Is a comprehensive term.
Yes,
Lord, what only a minute. Your lordships may consider saying those who are appointed after the judgment are not entitled.
Correct.
Number two,
I just
The law has been introduced.
Exactly. So any of
unless your lordship says prospecting, it's not said.
correct.
Well,
And
bridge code.
codes, my lord. There is no bridge code.
my meeting is submit my lord, only one thing, my lord.
They must undergo
100,000 of us.
Because we have 1 lakh and the jobs are only 11,500 odd. And we are qualified. And they are qualified and they are occupying them. And they can go to secondary and whatever other. We can't.
That is exactly the point, my lord.
In RTI, we have that information.
Actually, what is happening? All this B.ed, D.ed, this is all that should go. Apparently, 4 years or 5 years, which may be good.
Everything included, all inclusive, yes.
Your choice.
But instead of 1 week, we're having 2 weeks, because this. Yes,
But the high courts can proceed, I guess, because they are going to get over.
High court should not, High court.
There is no
There will be a
There is one vital thing, Lordship. There is already a writ petition, Lordship, where we have sought that all appointments made after 28/6/2018 should be quashed. And Lordship have issued notice in that, Lord. That I have annexed the order, Lord, in my IA 54821.
At 2 p.m.
Yes.
From that date,
Union is not a party. I'll take, I'll request someone. Madhya Pradesh. I'm for the Madhya Pradesh. I'm for
Devesh there. Devesh, your notification.
Anyway, I'm here. I can always request the concerned department.
to apply this code about apply this code on 2 points. Now, the first is how many vacancies primary schools are still there across the country, all the states and Indian territories. Opportunity through which the B.ed candidates can train themselves up to make their qualification at par with D.ed candidates.
Or yes, or you can get this course done immediately from this open university.
The Lordship may say appointed B.ed candidate. I'm saying something against me, not appointed B.ed candidate.
No, I'm sorry, Manoj. It appears that that's been struck down by this court. Okay.
My lords, that was struck down.
Anyway,
We'll place it on record. We'll place it. Settled.
But in the meanwhile, may I ask what will be done for us? Because we've been left out. We have succeeded in every single court. And at the end, we are being told that we won't get anything.
You failed in the competition. Then
Didn't fail any.
Bengal Manoj, the board has already
Anyway,
decided
Manoj,
that
I am not
government
that senior. I can't talk like this, Manoj.
Only Mr. Mehta. I must admit,
Universal problem.
it's only Mr. Mehta
Yes,
because
the Lordship
he has a unique talent.
If the Lordship conducts a voting, it would be 99 versus 1.
Yes, you'll be the one. Yes. Your Lordships, if your Lordships are looking
Therefore, I'm able to laugh, Malord.
if your Lordships are looking for a constructive way out, I'm sure the learned SD will come back with whatever the numbers are. But it shouldn't be a situation.
No, Malord.
When I'm on my feet, I'm sure I shouldn't be interrupted.
So there is a Lord, your Lordship should not be interrupted. Should not interrupt him. Lord, now he has his zone of consideration expanded to your Lordship.
I think the audience equitably.
No, he says your Lordship should not interrupt when he is on his legs.
Mr.
Stand over 40 times without nothing.
Because we are the persons that can have it.
At least either that or that. The unit we are just that is what you wait. That is the primary. So that
কোনোদিনও অনলাইন করা সম্ভব লাস্ট কথা বিষয়টা শুনতে হচ্ছে
did this best.
What's in the queue, John? Normal devices, login the project. Last portion is needed.
Calcutta High Court, in view of Ram Charan Maurya's judgment, did not choose to follow Rajasthan.
My lord,
That's the right.
Krishna Maurya special
Which year is Ram Charan Maurya?
Is 20. Though there was this was an ancillary. My lord, your lordship.
this is my lord.
Your lordship's word will be the final word, my lord.
That's right.
All high courts taking different contrary views, my lord, have no relevance.
Created all this mess. In your meetings, your officer said that B.ed is a higher qualification than
The minister said sitting in his chamber without consulting LCT. That is the quick.
But in any case, all that is now water under the bridge. Your lordships have given a final verdict. I would agree with this application to say any appointment made before your lordship's final word should be protected is the request to the court, because there was a lot of fluidity in the whole law until that point of time. And these are, my lord, we are fighting in a court of law. These are small teachers. Somebody has given up jobs. Somebody's got married on the point that you have got a job.
What happens to us? I don't understand. What happens to us?
Well, let us not go into it. If need be, we will assist your lordship.
If they go technical, then they win.
No, my lord.
Another problem.
Yes.
And my lord, on the lighter side, on this, my lord, if your lordship like to have a poll here, lord, I will win on my proposition.
Out of fear.
The first step will you don't have any constitutional bench to address.
Yeah. Right, my lord.
One last request, again, one last request, because I am in the state of duty that in that writ petition, lordships have issued notice. That will affect not because any
Is it before us?
It's before
before your lordship, lord, before your lordship, decided by your lordship, honorable justice,
Not the special bench, but before justice.
before justice.
Okay, is it coming in one of these days?
Yes, lord, it is coming within a week.
Find a
Or lordship, I will give a number to the court master if they made, because that has not been, that will affect in any case, lord, because there are certain,
bench combination has to release.
because that also relies upon judgment of Devesh Kumar, my lord.
Okay.
Yes. Yes. So not
When the matter is called up, is reminder.
because it has not been, every time it gets deleted, that is why I am saying.
That cannot be held.
I will get the number to the court master, my lord, right now.
I don't
That maybe that because
I don't think it's
Obliged.
correct. I think that we separate.